Hello everyone and welcome to the April 2024 episode of My PIP Monthly. As always, my name is Amber Ross Holloway and I'm a partner here at our Troy office. Today I'll be joined by Caitlin Milroy, also a partner here at our Troy office, and we will be discussing, of course, a case law update. Well, this month it's going to be a discussion and an update. The first case I have up is Central Home Healthcare Services v. Progressive, and that is a new case that I wanted to discuss. And then I'll move on to some older unpublished Court of Appeals opinions regarding fraud in the MAIPF. And those are the cases of Bakeman v. Citizens and Ronnie Fields v. National General Insurance Company. And then Katie will take over from there with the trending topics in PIP litigation, discussing the impact of the latest changes to the one-year back rule. First up, we have the case of Central Home Healthcare Services v. Progressive. This is a to-be-published opinion that was handled by Secrets-Wardle at the trial court level and on appeal. And here, the Court of Appeals unanimously held that reimbursement for home health services is limited to 200% under MCL 500-3157. Now, ultimately, this case stemmed from plaintiff's action to obtain payment for alleged in-home skilled nursing care and in-home physical therapy that it provided to defendants insured. Now, at the trial court level here, defendant Progressive moved for partial summary disposition under MCR 2.116C10 on the grounds that plaintiff was precluded under MCL 500-3157-2A from recouping the full amount of claim damages. Now, ultimately, at the trial court level, defendant argued that under MCL 500-3157-2A, plaintiff was limited to recovering 200% of what Medicare would have paid for the subject services here. And like I said in the last slide, it is residential care and physical therapy services. Now, in response, plaintiff argued that this section of the statute did not apply to this case because there was no fee schedule under the Medicare for in-home healthcare services, and Medicare, for the purposes of the No-Fault Act, did not provide an amount payable for these specific services. Now, ultimately, of course, the trial court agreed with plaintiff and denied defendant's motion, and here we are today. Now, in this unanimous published decision, the Court of Appeals reversed the trial court, and in doing so, the panel considered the argument one purely of statutory interpretation. Now here, the court's opinion focused on the statutory language of MCL 500-3157-2A and 3157-15F, noting that under subsection 2A, a provider that rendered treatment or rehabilitative occupational training to an injured person between July 1st, 2021 and July 2nd, 2022 is limited to recouping 200% of the amount payable. Now, since subsection 2A clearly states that if Medicare provides coverage for the treatment or service, then the provider may recover from the no-fault insurer for up to 200% of the amount Medicare would pay or the amount payable. Now, subsection 7, in contrast, provides that limitations cap only if Medicare does not provide an amount payable for a treatment or rehabilitative occupational training under the Medicare provisions. The opinion further goes on to define what Medicare is in section 3157-15F and states that fee-for-service payments under Part A, B, or D of the federal Medicare program all constitute Medicare. Although the definition of Medicare is discussed in the opinion, the main question here before the panel is to determine whether MCL 500-3157 Section 2 or MCL 500-3157 Section 7 applies, and whether Medicare covers the specific services at issue. And the panel ultimately found that Medicare did cover the services at issue. The court concluded that for the purposes of MCL 500-3157 subsection 7 does not apply if Medicare covers the treatment or services at issue, because coverage under Medicare means that Medicare provides an amount payable for the treatment. Now, under the factual circumstances here, the fact that Medicare covers the services means that the limitations cap that's provided instead by subsection 2A applies. Now, subsection 7 only applies if there is no Medicare coverage for the treatment at issue. So, therefore, the trial court did err by determining that subsection 7 was the controlling provision in the case and not subsection 2A. So, ultimately here, the plaintiff would be limited to the majority that they could claim is maximum 200% of what Medicare would have paid. So this was remanded back to the trial court to determine what that amount would be and to determine the proper calculations for that amount. Now, first up, we have the case of Bankman v. Citizens Insurance Company of the Midwest. And this is first up in the two cases that I wanted to discuss that talked about fraud with regard to the MAIPF and how the MAIPF can protect themselves or defend against fraud when plaintiffs are coming to them from policies not issued to the specific plaintiff. Now, this case specifically states that entitlement to benefits through the MAIPF is governed by MCL 500-3173A, that where a person commits a fraudulent insurance act and goes on to state specific elements to how that person is to commit that fraudulent act and what things have to be satisfied in order for dismissal to be appropriate. One, when the person presents or causes to be presented an oral written statement. That statement is in part of or in support of their claim for no pot benefits, and their claim was submitted to the MAIPF. Further, 4, the person must have known that the statement contained false information, and 5, the statement concerned a fact or thing material to the claim. And that's the case of Candler v. Farm Bureau Insurance Company. Now, here in Bankman, the plaintiff was severely injured as a passenger in a motor vehicle accident. Neither the plaintiff nor the driver had no-fault insurance, so plaintiff sought and received PIP benefits through the MAIPF, which were administered by defendant here, Citizens. Subsequently, plaintiff was hospitalized for approximately 6 weeks, following which he was prescribed attendant care and house care 7 days per week, 12 hours per day. Now, at a video deposition later on, plaintiff testified to receiving attendant care services for 8 hours a day, 5 days a week from March through May 2019. However, the claim forms that were submitted to defendant claimed 12 hours of care per day, 7 days a week during that same exact period. Plaintiff's signature was on those forms, and plaintiff testified that he did not sign any of those forms, and he answered, "I believe so," when asked whether his signature had been copied onto the forms by someone else. In further contradiction, plaintiff's own testimony, he agreed that it was indeed his signature on the forms. Now, the case of Bankman goes on to state that it is well established that self-conflicting testimony does not necessarily allow a party to manufacture a question of material fact. It states that courts should not presume that either of two arguable contradictory statements is the true one, and that a case-by-case approach in analyzing the inconsistent deposition testimony has been typically adopted by the Michigan Court of Appeals. Now, in this case, after a review of plaintiff's self-conflicting deposition testimony, it could only be determined that plaintiff did indeed commit a fraudulent act. Now, plaintiff did argue that there was no evidence that he had any intent to defraud the MAIPF, and that the errors in the forms were immaterial, and he did not sign the forms, nor did he review the forms after they were filled out. The Court of Appeals went on to determine that plaintiff's subjective intent was irrelevant, and the critical concern here is whether plaintiff knew that false material information had been provided. Also, the identity of the service provider was material to plaintiff's claim. And third, plaintiff cannot rely upon the lack of knowledge of the forms because the law is clear that one who signs an agreement in the absence of coercion, mistake, or fraud is presumed to know the nature of the document. Moving on to the case of Ronnie Fields v. National General Insurance Company, another unpublished opinion of the Court of Appeals that deals with the issue of fraud in the MAIPF. Here, a plaintiff was hit by a car while riding a bicycle in Flint. He sustained serious injuries, including multiple broken bones and lacerations, blunt force trauma to the chest and abdomen, and a traumatic brain injury. Plaintiff submitted 2 applications for benefits through the MAIPF. The first application was dated October 4th, 2019, and the second was a month later, November 4th, 2019. Now, once litigation started, the discovery process revealed that plaintiff's 2 applications for benefits were riddled with misinterpretations. Now, because of that, defendant Nationwide filed a motion for summary disposition, which the trial court did indeed grant and held that there was no genuine issue of material fact as to whether plaintiff committed fraud, and thus he was ineligible for PIP benefits. Specifically, the trial court ruled that plaintiff violated MCL 500-3173A by knowingly submitting false statements in support of his claim for benefits. Now, on appeal, plaintiff first argued the case of Williamson v. AAA, that any medical records or deposition testimony obtained after litigation was commenced could not be used to defeat plaintiff's claims. Specifically in the case of Williamson, the Fraudulent Insurance Provision Act was discussed, but it indicated that it does not apply to statements made after litigation had ensued. Next, the plaintiff argued that 2 applications for benefits were submitted to the MIPF must be considered inadmissible hearsay under MRE 801 and 802. And lastly, the plaintiff argued that defendant Nationwide could not show that the plaintiff intended to commit fraud within the meaning of MCL 500-3173A4. Now, ultimately, the court held that the medical records did not fall under the Williamson umbrella and were properly considered by the trial court. The statements at issue here were admissions by a party opponent under MRE 801. However, when the court considered whether they should be inadmissible under MRE 803 due to lack of trustworthiness, the court ultimately was not convinced that the trial court correctly concluded that no genuine issue of material fact existed as to whether plaintiff knew or understood the contents of the October 4, 2019 application. Now, as for the second application that was submitted a month later, the court stated that the plaintiff merely argued that he did not know what he was signing because he was blind and nobody read him the contents of the application. Now, ultimately, these 2 cases taken together show that it's really up to the Court of Appeals. It seems as if they're going back and forth. In the second case, there was written documentation of misrepresentations as well as the first case. However, in the second case, there were issues regarding a TBI, which the court did seem to analyze and adhere some weight to, given that plaintiff had the TBI and was indeed blind, and there may have been some issues with regard to if plaintiff knew or did not know what he was signing.
Hello everyone, my name is Caitlin Milroy and I am a partner at Seacrest Wardle at the Troy office. I wanted to take this time to first discuss a topic that I have noticed come up a lot on my end since no-fault reform took place on June 11th, 2019, and that is the impact of the latest changes of the 1-year back rule of MCL 500.3145. These questions include: what are the changes? When does the 1-year back rule now apply? When can a motion for summary disposition be filed in this regard? With that, we will tackle this issue head-on by discussing the following. We will compare the old 1-year back statute versus the new statute. We will discuss the applicability of the new statute to provider claims. Lastly, I wanted to discuss how the changes to the 1-year back have affected the filing of motions for summary disposition relating to bills with 1-year back issues. The full statute is indicated in the PowerPoint slides, but the old statute of MCL 500.3145 previously read, in summary, it more or less stated that a claimant may not recover benefits for any portion of the loss incurred more than a year before the date on which the action was commenced. Thus, the 1-year back defense was a lot more cut and dry, and it was easier to figure out if a 1-year back motion for summary disposition could be filed. The statute was recently amended on June 11, 2019 to include additional language and requirements to the 1-year back rule. I have provided you with the actual statutory changes on the next 3 PowerPoint slides, but I will simply summarize and analyze these changes rather than reading it word for word for the readers. So, what are the consequences of this amendment? What has changed? The legislature has now inserted a tolling provision that allows the time limit on the 1-year back rule to stop running once a claimant makes a, quote, specific claim for PIP benefits, unquote, until the insurer, quote, formally denies the claim, unquote. Tolling will now apply if the claimant pursues his or her claim with, quote, reasonable diligence, unquote. There is now a new notice requirement for claimants, which is essentially a written confirmation of claims. This newer provision stems directly from a 1986 Michigan Supreme Court case called Lewis v. Detroit Automobile Inter-Insurance Exchange. Now, let's unpack these statutory changes a little bit. First, what is a specific claim for benefits? It is sufficient information to be informed that plaintiff suffered a compensable loss. A specific claim for benefits allows the insurer to be aware of the extent of plaintiff's injuries and medical bills throughout the investigation. Second, what constitutes proper notice? Pursuant to the new statute, a person will be barred from recovering PIP benefits unless they file an action within 1 year of the accident, they have given written notice to the insurer within 1 year after the accident, or a payment has been made by the insurer. Also pursuant to the new statute, a claimant's written notice shall give name of the claimant, address of the claimant, name of the person injured, the time, place, and nature of the injury. The best example of this would be an application for no-fault benefits. Third, what constitutes pursuit of a claim with reasonable diligence? Black's Law Dictionary's definition of reasonable diligence is a fair degree of diligence expected from someone of ordinary prudence under circumstances like those at issue. Timely responding to requests for information from the adjuster, for example. Regardless of the 1 year back rule, proper written notice must still be given to the insurer within 1 year of the accident. Lastly, what is a formal denial by the insurer? A formal denial necessary to end tolling must be explicit and unequivocally impress upon the insured the need to pursue further relief in court. Last year, in the Encompass Healthcare versus Citizens case, the Michigan Court of Appeals addressed the interplay of the 1 year back rule, the 2019 no-fault amendments, and the formal denial of claims under MCL 500.3145, in holding that until there is a formal denial of a claim, application of the 1 year back rule remains tolled until the filing of a lawsuit. That Court of Appeals opinion was issued on November 17, 2022. Now focusing specifically on provider suits now. With the no-fault reform, MCL 500.3112 was amended to allow medical providers a direct cause of action to recover PIP benefits against a no-fault insurer, and provides in pertinent part the statute indicated on the PowerPoint slide. This change means that if a provider files suit after June 11, 2019, then that provider is not required to have an assignment from its patient in order to have the right to sue the insurer. However, the provider's claim is still derivative of the patient's claim, and it therefore does not have any greater rights than its patients. Thus, providers are still bound by the time limitations contained in MCL 500.3145, or the 1 year back rule. The very last thing I wanted to discuss today is the impact of the changes to the 1 year back rule to the filing of motions for summary dispositions, attempting to dismiss bills barred by the 1 year back. The changes to the 1 year back rule have certainly changed defense dispositive motion practice greatly. When you are thinking about filing a motion for summary disposition based on the 1 year back rule, you can no longer just subtract a year from a suit's filing date and go off that. For accidents taking place after June 11, 2019, you have to look at whether there was proper notice of the claim and if and when the claim was formally denied versus a claim still under investigation to determine when the 1 year back would kick in and no longer be tolled. For accidents taking place before June 11, 2019, one can argue that the new statute is not retroactive and thus inapplicable to the matter, and the old 1 year back statute should apply. This is because the new statute is silent on retroactivity, and this should be taken into consideration when deciding the viability of a dispositive motion on the issue. Thank you for attending the MyPIP Monthly for the month of April 2024. Please contact us with any questions or comments you may have.